Brighton and Sussex Medical School, MSc Module MDM122B, Communication, Learning and Teaching in Health and Social Care, a teaching video, January 2020. Title of the teaching, Mental Health Act. The objective of this presentation is to be familiarized with Mental Health Act and the related terminologies. The target audience, trainee doctors and other trainee professionals. Duration 10 minutes. Mental Health Act 1983, amended in 2007 and 2018. This is an act of Parliament of the UK, but it only applies to England and Wales. It covers the reception, care and treatment of mentally disordered people, the management of their property and other related matters. It allows to assess under Mental Health Act by an AMP and 2 doctors to detain a patient and treat them for their mental health problem. In order to detain them, a patient who has a mental disorder means any disorder or disability of the mind. And also there should be a risk to their health or risk to their safety or for the protection of others. People involved in the Mental Health Act. The nearest relative, it is a legal term, not the same as next of kin. And the AMP is an approved mental health practitioner who are specially trained professional to carry out the Mental Health Act assessment. Doctor and Section 12 approved doctors. Doctors mean qualified registered doctors. Section 12 approved doctor mean who are specially trained to do the Mental Health Act assessment. RC mean responsible clinician who is responsible for the care of the mentally ill patient. Hospital managers mean independent people who make sure that the Mental Health Act is rightly practiced. Mental Health Tribunal. Mental Health Tribunal is a special court to deal with cases related to Mental Health Act, and they have the right to discharge a patient and recommend anything if necessary. IMCA, Independent Mental Health Advocate, they are specially trained people to speak on behalf of the patient. CQC means Care Quality Commission, which review and regulate the Mental Health Act and the practice. Police and the solicitor often represent the patient in the Mental Health Tribunal or in the manager's hearing. Section 136. This section allows the police to take someone from a public place to a place of safety and keep there for 24 hours, and it can be extended further 12 hours if necessary. Before using the section 136, the police must consult a health professional, and the patient has no rights to appeal. Within that 24 hours, a Mental Health Act assessment should be happened. A place of safety means it could be a police station or a hospital or home of that patient or someone else in case the patient agrees to that. Section 135. Section 135 allows the police to enter into someone's home and take someone to a place of safety so that a Mental Health Act assessment can be done. The police must have a warrant from the magistrate court allowing them to enter into someone's home. The police can keep them up to 24 hours. It can be extended further 12 hours if necessary, and patient has no right to appeal against this. Section 5.4. Holding power. If a patient already in a hospital informally and won't leave the hospital, and the nurse worried about the patient's safety or health or for the protection of others, the nurse can stop the patient leaving the hospital under this section. Nurse can hold the patient for up to 6 hours, and this cannot be extended further. And also the patient has no rights to appeal against this. And also the clinician has no right to treat without consent under this. Section 5.2. This section applies to voluntary patient or inpatient, including patients being treated for a physical health problem. If the doctor worried about patient's safety, health, or for the protection of others, the doctor can detain the patient for up to 72 hours. In that 72 hours, a Mental Health Act assessment should happen, or the RC can discharge the patient. This section cannot be extended and cannot be appealed against it, and the doctors have no rights to treat without consent during this period. Section 4. Usually, 2 doctors and M requires to do the mental health act assessment. In this case, 1 doctor and 1 M can do the mental health act assessment. Patient can be detained if patient has a mental disorder and it is urgently necessary to be admitted to hospital and detained, and also waiting for a second doctor to confirm what caused undesirable delay. In that case, Section 4 can be applied. Under this section, patient cannot be treated without consent, and patient can be detained up to 72 hours, and the patient has no rights to appeal against this. Section 2. In order to detain someone under this section, a mental health act assessment needs to be carried out by 2 doctors and an M. And also, the following criteria must be met. The first one is someone has a mental disorder, and the second one is need to be detained for a short time for assessment or possibly for medical treatment. And the third one is it is necessary for someone's own health or safety or for the protection of other people. Under this section, the patient can be detained for up to 28 days, and this cannot be extended or renewed, and can be treated without consent during that period. And also, patient has the right to appeal against this within first 14 days of the Section 2. Section 3. In order to detain someone under this section, a mental health act assessment needs to be carried out by 2 doctors and 1 M, and patient can be detained if the patient has a mental disorder and for health or safety or for the protection of other people, and also there should be appropriate treatment available for this condition. A patient can be detained for up to 6 months, and this can be renewed or extended every 6 months and twice and after 12 months. And also patient can be treated without a consent during this period. Leaves. The leaves are covered in Section 17 of the Mental Health Act, and thus we call it Section 17 leave. It is only given by responsible clinician. It can last up to 1 month, and it always attached to conditions. CTO is a community treatment order. People who are on Section 3 or 37 can be discharged on community treatment order, so they can have the treatment in the community. And always it has some conditions such as complying to the treatment and engaging with the team. CTO recall. People who are treated in the community under CTO can be recalled if they are relapsing or they are not compliant with the treatment. The guardianship. This focuses on welfare rather than on medical treatment. A court can appoint a guardian who can take some decision about the patient's care, and they have some legal power. Section 117 aftercare, it means that people who are detained under Section 3 or 37, on their discharge, they can have some free help, such as free accommodation and other social care help. Forensic sections. These sections are for those who are involved in crime. Section 35 allows the criminal court to give a court order to a person to be assessed in the mental health hospital for up to 28 days. Section 36 allows the court to give a court order to be treated in the mental health hospital for up to 28 days. Section 37 allows the court to give a court order for hospital treatment up to 6 months. Section 38 allows the court to give a court order for convicted people to be treated in the mental health hospital for up to 1 year. Section 41, it is a restriction order to the other section. For example, when we say Section 37/41 means the Section 31s come up with some restriction from the court, such as the patient cannot have leave or patient cannot be discharged, and etc. Section 47, it is a section allows sentenced prisoner to be transferred to hospital and treated for mental health problem under this section. And Section 48, prisoners who are without sentence to be transferred to hospital and treated for any condition. And also Section 49 is a more restriction. For example, if Section 47/49 means Section 47 come with some sort of restriction, such as the patient cannot have leave or patient cannot be discharged, and etc. Medical treatment of patients who are detained under the Mental Health Act. For the first 3 months, doctors doesn't require consent from the patient to treat the mental health condition. After 3 months, a 2-2 form must be filled in if the patient have the capacity and consenting to the treatment. If they do not have the capacity or refusing the treatment, Section 62 allows the emergency treatment until the T3 form is filled in. A T3 form is for patient who lacks capacity or refusing the treatment. This must be filled in by SOAD. SOAD means Second Opinion Approved Doctor, which is appointed by CQC to fill in the T3 form. Electroconvulsive Therapy and Mental Health Act. The ECT is not covered in T2 or T3 form. If we want to give an ECT to a detained patient, a T form must be filled if they are adult and consenting to the ECT, and it can be filled by an RC. A T5 form must be filled if they are under 18, and it can be only filled by Second Opinion Approved Doctor. A T6 is for all patients who lacks capacity or who refuses ECT, and it can be filled by a Second Opinion Approved Doctor. The Mental Health Act doesn't cover the physical health treatment, and we cannot treat any physical condition without consent under Mental Health